Exposure to toxic chemicals like PFAS and PFOA are a serious public health risk, and cancers are increasing in our children because of increased exposure compared with previous generations. PFAS and PFOA fluids can migrate to rivers and aquifers. OCC must prohibit PFAS in oil and gas operations because without a prohibition, there's no guarantee that contamination of our drinking water will not occur. Because more than 3,600 New Mexico wells have already been contaminated, the harm is already being done. To stem the tide, the OCC should, at a minimum, set rules in place governing oil and gas drilling to prevent these contaminations. Requiring those disclosure requirements does not make us safe, but disclosure is a minimal step in the right direction. Again, thank you for the opportunity to provide comment, and we ask you to be guardians of our well-being by passing a prohibition of the use of PFAS and PFOA chemicals in oil and gas operations.
Thank you, Ms. White. We'll take one more comment. I see a hand, NS. Let's see. Nancy Singham.
That's me.
Oh, hello. If you would state and spell your name for the record.
Nancy Singham. It's spelled Nancy. Singham is S as in Sam, INGHAM.
Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your 3 minutes.
Thank you, commissioners. I'm a retired kindergarten teacher. I'm 75 years old, and yet I have a very vivid memory of 2 small events from my childhood I'd like to share. One must have dated from about 1957 or so. I was standing next to my dad in our plot at the neighborhood garden as he was dusting his garden with a hand-cranked metal canister duster, which certainly contained DDT to kill insect pests. By the way, the products from this era carried trade names from their oil company manufacturers, such as, I looked it up, Shell Tox Aerosol and Standard Oil Aerosol Insect Killer. A few short years later, maybe 1962 or 1963, I distinctly remember my mom, who was an avid bird watcher, telling me about a shocking new book she was reading by a scientist named Rachel Carson about how the chemical DDT was causing eagle eggs to crack and species numbers to plummet. Now, the point of these reminiscences is this. Through my entire lifetime, we have been affected by multiple examples of products and processes launched for profit with deceptive and false promises, without testing or without concern for the health impacts on people, air, water, and land, leaving us, the victims, to belatedly resist in hearings such as this one. Jumping to the present, knowing as I do that New Mexico has already allocated every drop of water available, I took note of a recent article referencing a major study in the respected journal Science. It's the with the headline, millions of people in lower 48 states may be relying on PFAS contaminated groundwater for drinking. This is a really long, complicated study, appeared in Science magazine October 24th of this year, so I urge you to have a look at it. They studied both deeper community wells as well as shallower private wells used for drinking water, where their models results indicated that 71 to 95 million people in the United States potentially rely on groundwater with detectable concentrations of PFAS for their drinking water supplies. And they also listed in great detail 24, they were looking for 24 different PFAS type products and looking for sources, and their sources included airports, plastic and resin manufacturing plants, oil and gas extraction sites, refineries, power plants, mining operations, fire training areas, national defense sites, and at least a dozen more. The danger of drinking water contamination by PFAS use in oil and gas drilling is real. We need to learn from history before it's too late. So I support a prohibition on PFAS and PFOA in oil and gas operations and a requirement to disclose chemicals used in these operations. Thank you very much.
Thank you, Ms. Singham. One more, and if anyone else is on the platform wishing to offer public comment, I'll invite you to rejoin us at 1:15. But for right now, we're going to hear from Ryan Tate. Ryan Tate?
I
Oh,
am
hello.
here. I'm sorry about
Hi.
that.
That's all
Hi.
right. If you would state and spell your name, please.
Of course I can. That's going to be Ryantate.
Thank you. And do you swear or affirm to tell the truth?
Yes, I do.
All right. I'll start your 3 minutes.
Wonderful. Thank you very much. So, my full title is Reverend Ryan Tate, and I am actually the youth minister at First Congregational United Church of Christ. I am also the head pastor at the First Spiritual Church of the Rio Grande in Albuquerque, New Mexico. Now, environmental contamination is violation of land autonomy. We walk on the soft, dirt-laden belly of a family member, the mother of us all. Separable, or your destiny is separate from her. When speaking of PFAS, I believe we must ask ourselves if we would consent to the unregulated disposal of these forever chemicals into our very own bodies. Would we allow our own government officials and corporate overseers to hook us up to an IV filled with these carcinogenic mutagens as we helplessly watch on? We live in a country with a tenuous grasp of bodily autonomy and dissonant understandings of ownership and possession. We see it play out in how we treat our most vulnerable and how we treat the earth. Would you allow your own mother to be forced to take the IV of these PFAS on behalf of the few? Would you at least want her to speak or give her the chance to do so? In the scenario we are entertaining, an Earth without autonomy, we would not listen to her cries, we would ignore her plight, and instead subject the Earth and our mothers, and all living things to the dangers of PFAS. These are particularly nefarious when entering our waterways in an already ecologically vulnerable environment, which is the Southwest. Water is life, and water is the gateway that links our past, present, and future. Our children will drink the poison of our actions if we do not act now. It is a spiritual imperative that we take care of one another as well as all living beings. That means stricter environmental regulations for forever chemicals and other long-lasting contaminants, and for the companies, corporations, and government entities that produce them as well. And that is the end of my statement.
Thank you very much, Reverend Tate. All
Thank
right.
you. Have a good day.
Thank you. We're going to break for lunch now. We'll return at 1:15. If there is more public comment to be given, we will take it. Otherwise, we will move to opening statements. Thank you all. It says my microphone is muted. Let's come back from the lunch break, please. All right, we broke for lunch. We are back now. First, let me ask in the room, is there anyone here who would like to offer public comment who has not already commented? No. All right. Is there anyone on the platform who would like to offer public comment who has not already commented? Please raise your hand. I see AR. And this
Yes.
is Anna Rondon. All right. Would you
Yes, it
state
is.
and spell your name, please?
Anna Rondon, ANNARONDON.
Thank you. Do you swear or affirm to tell the truth?
Yes, I do.
All right. I will start your 3 minutes.
Thank you. Dear members of the New Mexico Oil and Gas Commission, my name is Anna Rondon, and I stand before you as an Indigenous woman, Navajo woman, deeply committed to the protection and well-being of our communities. I am here to urge the full disclosure of PFAS contents in our water sources and to highlight the critical need for transparency and accountability. Throughout history, and in particular United States history, there has been significant and tragic instances where industries have withheld crucial information from the public, resulting in severe health consequences. The tobacco industry's failure to disclose the addictive chemicals in cigarettes stands as a stark reminder of devastating impacts that a lack of transparency can have. Despite clear evidence of the harm, the tobacco industry chose profit over people's lives, leading to the widespread addiction, illness, and death. The people won major lawsuits with this industry, and any industry that has posed damage and harm to our people should have lawsuits filed. We now face a similar threat with PFAS, often referred to as forever chemicals, due to their persistence in the environment and the body. PFAS contamination has been linked to numerous health issues, including cancer, liver damage, and developmental problems. As these chemicals infiltrate our water supplies, the health and safety of New Mexico residents are at risk. It is imperative that the New Mexico Oil and Gas Commissioners take decisive action to protect its citizens. We demand full disclosure of all PFAS contents in our water sources. The public has a right to know what's in their water, and transparency is the first step towards addressing and mitigating this serious issue. The parallels between the tobacco industry's past actions and the current situation with PFAS are very clear. Both involve the concealment of dangerous substances and their resulting harm to the public health. As an Indigenous woman, a Kia'ani clan woman, I am acutely aware of the profound connection between communities and the land and water that sustains us. We have a responsibility to safeguard these resources for future generations, and we must be protected from the effects of PFAS. I urge the New Mexico Oil and Gas Commissioners, I plead with you to prioritize transparency, accountability, and public health. Let us not repeat the mistakes of the past. Full disclosure of PFAS contents is not just a necessity, it's a moral imperative. Thank you for your attention and the commitment and the oath that you took as commissioners to stand for the citizens of New Mexico. In beauty it shall be. Ahiahet, thank you.
Thank you, Ms. Rondon. Is there anyone else on the platform who would like to offer a public comment now? There will be more opportunities tomorrow, Thursday and Friday. Don't see it. Oh, I Sue Sherman. Let's see. There you are.
Can you hear me?
Yes. Would you state and spell your name for the record, please?
Sure. Thank you very much. My first name is Susan, Susan, and my last name is Schurman, Schuurman.
Do you swear or affirm to tell the truth?
Yes, I do.
I'll start your 3 minutes.
Sure. Thank you very much. I just have a very brief statement. I would like to urge the OCC to take the reasonable step to require companies to disclose what chemicals are in the drilling fluid, because the health of workers and everyone who drinks water is at risk. PFAS is just too dangerous in tiny amounts not to take this protective action. Thank you very much.
Thank you very much. Anyone else on the platform interested in offering public comment at this time? All right. In that case, we are going to turn to the technical case consistent with the public notice of this matter. Sheila, before I forget, if you would please, if someone else gets on the platform and asks when they might be able to make public comment, please tell them I won't invite it again until after the first technical witness, and that if they want a more time certain, they can join us at 8:30 tomorrow morning.
Okay.
All right.
Thank you.
All right. So we have 6 parties, excuse me, with EOG, and each party is allotted 20 minutes for an opening statement. You may make your opening statement right now, or you may reserve it. Certainly, I think NEE is going to reserve, so I don't believe they're with us right now. Mr. Davis, would you like to start?
I would. Thank you, Madam Hearing Officer. Good afternoon, Commissioners. My name is Tim Davis. I represent Wild Earth Guardians, and the petition that you accepted asked a very simple question of you. It asks you to ban the use of PFAS substances in downhole operations, and then it requests full disclosure of all chemicals that are used in downhole operations in order to enforce that ban. And if we don't know the chemicals that are going downhole, then we can't be certain that those chemicals are not PFAS. This proposed rule is rooted in the fact that PFAS poses a serious public health threat and an environmental threat. It also recognizes that as the law currently stands, regulators do not know all chemicals that are being used in downhole operations, and neither does the public. It is important to note that Guardian's proposed rule does not require the disclosure of trade secret chemicals. It simply prohibits the use of undisclosed chemicals. So in other words, it puts a choice to the holder of the trade secret. They can either disclose it and use it, or they can keep it as undisclosed, but not use it in New Mexico. The oil and gas industry is currently disclosing a significant amount of chemical information per the regulations that we have right now, and they're disclosing that on the Frac Focus database. And in an op-ed that NMOGA submitted on Saturday to the Santa Fe New Mexican, they recognize the fact that they're already disclosing chemicals in the Frac Focus database. But in this same op-ed, NMOGA misrepresents the law and misleads the public into believing that all chemicals are disclosed, conveniently leaving out that current disclosures include chemicals whose names and chemical abstract numbers are withheld as proprietary. Obviously, if there was already a requirement for full chemical disclosure in New Mexico, like there is in California and Colorado, we wouldn't be here today asking you to require it. In order to carry out our proposed provisions to ban PFAS and undisclosed chemicals in downhole operations, we've also included proposed changes to the definitions and adopted proposed red lines from OCD that are related to testing for groundwater contamination. And we've also included proposed community notification provisions. And again, I'd like to make clear that Guardian's request is to ban PFAS and undisclosed chemicals in all downhole operations. And my experience with these rulemaking hearings is that I often learn during the course of the hearing. And so acknowledging that, I'd also request that Guardians has an opportunity to present a final proposed red line rule to the commission to ensure that our proposed red line does carry out our intent here, which is to ban all PFAS in downhole operations and ban all undisclosed chemicals in downhole operations. So I'd like to briefly just state that you have statutory authority to adopt our proposed regulation, and that is in the rulemaking provisions, powers that you're given under 70-2-12B15 relating to the regulation of produced water, as well as subsections 21 and 22 related to the regulation of non-domestic waste. You will hear from 3 technical witnesses from Guardians. First, you'll hear from Dusty Horwit, and Mr. Horwit is in the hearing room with us today. He's a lawyer and the author of 7 reports related to the use of PFAS and loopholes which prevent full disclosure of chemicals used in oil operations, including a report focused on New Mexico. His testimony draws on these reports and his research to explain that the use of PFAS has already been disclosed by oil and gas operators in New Mexico. Gaps exist in our chemical disclosure reporting requirements, and that these gaps prevent regulators and the public from knowing all chemicals that are used in oil and gas downhole operations, including ones that may not start off as PFAS, but could break down into PFAS. Mr. Horwit's testimony further explains that other states have closed similar data gaps. You will also hear from Professor John Spear. He's a professor of civil and environmental engineering at the Colorado School of Mines, and his specialty is subsurface environmental microbiology. His testimony explains that oil and gas wells will eventually leak at some point. And this is due to microbial-induced corrosivity, seismicity, or a combination of those 2 factors. And that this requires indefinite retention of the disclosed chemical information. Dr. Spear also explains that the subsurface is alive and is an ecosystem itself. And that should also be protected from PFAS and undisclosed chemicals. We should at least know what we are putting downhole. His testimony further shows that chemicals used in downhole operations can spread through fate and transport processes, and that deep strata can and do communicate with shallower strata. Dr. Spear will also appear in person. Next, you'll hear from Dr. David Brown. He's a public health toxicologist. He has extensive experience working on public health issues affecting communities in the Marcellus Shale oil and gas fields, and has co-led several studies of oil and gas impacts on communities at the Southwest Pennsylvania Environmental Health Project. Dr. Brown's testimony focuses on the toxicity of PFAS, the need for complete chemical disclosure from a public health standpoint, and the public health lessons learned from the Marcellus Shale. Dr. Brown will appear on the Microsoft Teams platform. We also have 1 fact witness, that is Melissa Troutman. Ms. Troutman is the climate and energy advocate with Wild Earth Guardians, where she works with communities and individuals impacted by oil and gas spills and emissions. Her testimony is a compilation of state-held data. This data comes from OCD databases and acknowledges that fluid spills can and do happen. And at times, these spills affect our freshwater resources. Because fluid spills can contain contaminants used in downhole operations and are a potential pathway to exposure, Guardians submitted Ms. Troutman's testimony to make sure this state data is part of the record in this proceeding. Ms. Troutman also references an NMED webpage where the Environment Department acknowledges that 78% of us get our drinking water in New Mexico from groundwater sources. Because the overwhelming majority of New Mexicans get our drinking water from groundwater, we should know the universe of potential contaminants when a spill occurs or when the integrity of a well is in question. Also note that Wild Earth Guardians Exhibit 7 is the New Mexico Bureau of Geology and Mineral Resources report entitled Climate Change in New Mexico Over the Next 50 Years, Impacts on Water Resources. As the report acknowledges, our freshwater resources are only going to become more scarce due to climate change. I'd like to briefly talk about the fact that what we're asking for is already the law in California and Colorado. California and Colorado both require full chemical disclosure on the oil field without regard for trade secrets. Those laws are Wild Earth Guardians Exhibits 4 and 5, and just like the proposed rule, they require full disclosure. This means that each individual chemical in a chemical product that's used in California and also in Colorado must be disclosed. And if that same chemical product is used in New Mexico, it does not have to be disclosed. In New Mexico, those chemicals could be claimed as proprietary, and this rule seeks to change that. We ask that New Mexicans are afforded the same protections and access to chemical safety data that Californians and Coloradans already have. I'd like to touch briefly again about the op-ed that was published on Saturday by NMOGA, just to clear up what I think is something that's quite misleading. The op-ed stated that the industry is already, quote, the industry is already required by law to report their chemical usage and ensure that PFAS are not intentionally utilized while protecting proprietary information and trade secrets that keep American companies competitive. There is no PFAS ban in New Mexico. There is no requirement for full chemical disclosure in New Mexico. As I think some of the commenters pointed out this morning, before the governor was elected, she made a promise. And that campaign promise was that, quote, as governor, she would require the mandatory disclosure of what chemicals are used in hydraulic fracturing to better protect groundwater. That was in 2018, released during her gubernatorial campaign. And this proposed rule is aligned with that campaign promise. And it's an opportunity to further groundwater protections in New Mexico. Next, I'd like to just address some of the arguments that NMOGA made in their pre-hearing statement. First, there is an argument that Guardians is seeking to somehow conflate produced water with non-domestic waste or change the definition of produced water. We are not doing that. If we wanted to do that, we would have included a change in those definitions in our red line. So I just want to make clear that that is not what we're trying to do, and I don't think we need to spend any time on that at this hearing. Second, one of NMOGA's witnesses alleges that full chemical disclosure could cause something called chemophobia. That's a type of anxiety among communities in areas of oil and gas extraction. Interestingly, however, NMOGA does not argue that chemophobia already exists. After all, partial disclosure is already happening on Frac Focus. It's hard to understand how full chemical disclosure would be so much scarier than partial disclosure, or how it would somehow lead to an epidemic of anxiety. The bottom line is that the public should have a right to know what chemicals they are potentially exposed to so they can make the best decisions for themselves. Their healthcare providers should have access to that data, and that would help with diagnosis and treatment of ailments, which many peer-reviewed studies have confirmed do increase with close proximity to oil and gas operations. First responders should know what chemicals they and patients are exposed to in emergent situations. Researchers should know what chemicals they are looking for in characterization efforts or studies of subterranean ecosystems. And last but certainly not least, the regulators should know the universe of chemicals present at a spill site, or when there is a well blowout, or when a mechanical integrity issue is present. This would make cleanup and remediation more thorough and less expensive. In short, the industry is saying, trust us, but not the public, a public that includes professionals across many fields, doctors, emergency personnel, academic researchers, not to mention mothers, fathers, elders, children, oil field workers, and their families. We believe that trust requires transparency and accountability. And this is what New Mexicans deserve. Next, I'd like to talk about the definition of PFAS. NMOGA points out that 6 states use the PFAS definition proposed by their experts and assert that this definition is appropriate because it covers PFAS that we already know has been used in oil and gas. What they fail to say is that 23 states use Guardian's proposed definition, and that includes the Colorado PFAS ban and disclosure law. Wild Earth Guardian's Exhibit 8 compiles all these definitions from these 23 states. NMOGA also does not acknowledge that we only know certain PFAS have been used in oil and gas because those are the ones that have been disclosed. Without full chemical disclosure, we simply do not know what has been used, and there is no restriction on what could be used in the future. The Uniform Trade Secrets Act is not a barrier to promulgating the proposed rule. We would request the opportunity to brief this issue for the commission. I think this is a very important issue. And I'm going to briefly touch on it, but I would really like to be able to provide something in writing. The Uniform Trade Secrets Act does not prohibit disclosure of trade secrets. It provides a cause of action for, quote, the misappropriation of a trade secret, and it provides that you can sue for damages and or injunctive relief. Misappropriation is defined in the statute, but the bottom line is that disclosure by the holder of the trade secret is not misappropriation. The proposed rule does not require disclosure of trade secrets. It does not, however, also prevent a trade secret holder from voluntarily disclosing. If a trade secret holder will not disclose the trade secret, the rule simply says, well, then you cannot use that in New Mexico. But it is a decision for the holder of the trade secret to make. By the way, Colorado also has passed the Uniform Trade Secrets Act, and they require full disclosure. Quite simply, the proposed rule does not, quote, nullify the protections of the Uniform Trade Secrets Act as alleged by NMOGA. The commission has independent authority to regulate produced water and non-domestic waste to protect human health and the environment, and it can exercise that authority to ban the use of PFAS and undisclosed chemicals. And it can leave the decision of whether to disclose chemical identities to the holder of the trade secret. When a trade secret holder discloses, it is not misappropriation under the Act. Additionally, the disclosure of a chemical identity is like disclosing the ingredient to a recipe. We are not asking for disclosure of recipes. We are asking for disclosure of ingredients. It's notable that NMOGA acknowledges that trade secrets definition in the Uniform Act protects formulas, but it applies that definition to fracking constituents, and that's on page 20 of their pre-hearing statement. NMOGA then characterizes the choice to disclose as a Hobson choice, but it fails to acknowledge that the entities benefiting from the choice to disclose, doctors, researchers, government agencies, elected officials, emergency medical professionals, teachers, mothers, elders, etc. They fail to acknowledge that a chemical identity is not a trade secret. And if you read the Colorado and California acts, you'll see that that's what they've done in those states. They say in those laws that chemical abstract service numbers are not trade secrets. Formulas are, ingredients are not. In order to properly communicate the risk associated with injecting toxic chemicals underground at high pressure, especially in earthquake-prone areas, as well as risks associated with routine spills that can contain chemicals, community notification of what chemicals are involved is necessary. In our petition, we have proposed specific community stakeholders that should receive such communications, and there are no restrictions on how this communication can be delivered. And I'd also like to point out that it tracks the Colorado law that their legislature passed. That brings me to my last point about NMOGA's pre-hearing statement. While we agree that OCD, OCC have very limited jurisdiction to regulate to protect the environment and public health. For example, it cannot consider environmental impacts in permitting new wells. However, this commission can regulate produced water and non-domestic waste for the protection of the environment and the public health. That's the only place that those words appear in the Oil and Gas Act. Namoga argues that the commission has no jurisdiction to regulate the, quote, generation of produced water and non-domestic waste because the word generation does not appear in the Oil and Gas Act. However, in order to properly regulate produced water and non-domestic waste, OCD needs to know what constituents may be added in drilling, fracking, and other downhole operations. Chemical disclosure is needed to do this. Additionally, once chemicals are disclosed, the commission and division can regulate the disposition of a toxic constituent by banning it in the first place. In other words, the power to regulate what constituents might be added to produce water and non-domestic waste is inherent in its power to regulate the disposition of produced water and non-domestic waste. As an example, OCD has authority to regulate the disposition of waste contained in the pit rule. OCD has many rules governing pit waste, including regulations about specific constituents. For instance, OCD is able to regulate the amount of chloride in waste that oil and gas operators want to bury. The pit rule requires operators to fill out Form C-144, detailing the well information, the API number, the OCD permit number, well location, and the amount of chloride in the waste stream. And it also requires an oil-filled waste stream characterization of waste streams to be permanently buried. If OCD has the authority to regulate chloride in wastes, it also has the authority to regulate other constituents in oil and gas wastes like PFAS. So in conclusion, again, Guardians is asking you to ban PFAS and undisclosed chemicals in downhole operations. We request an opportunity to submit a final red line proposed rule after the hearing. And if the industry has transitioned away from using PFAS, then they should disclose all chemicals used in downhole operations to show that. If we don't ban PFAS now, nothing prevents its use in the future. Thank you.
Thank you, Mr. Davis. We don't have any E with us today, so they will necessarily be reserving their opening statement. Let me ask the division. Mr. Tremaine, would you like to do it now or later?
Yes, I'll proceed now. Thank you.
All right, thank you.
Good morning or afternoon at this point. Pardon me, Madam Hearing Examiner and Mr. Chair and the Commission and the public. I want to start by thanking the parties and the Commission. At the time of the first petition in this matter, the proposal looked remarkably different than it does today. And at that time, that was a proposal that OCD could not support. OCD requested time to secure expert services and engage in stakeholder discussions. And I want to highlight before we start this process that both the petitioner, Wildlife Guardians, and the regulated community engaged in discussions with OCD to find the appropriate way to make the core elements of this petition work. In particular, the petitioner worked with OCD and ultimately proposed a quite substantial revision to the original proposal. I also want to thank the public commenters and observers for their participation and thank everyone in advance for their patience and understanding. We're halfway through the first day of a 4-day hearing on extremely technical issues, which we are necessarily discussing within the framework of a discrete and very limited statutory authority. Some of the issues raised generally and in public comment cannot be addressed by this commission. But we are here, particularly the division is here, to work through this very complicated and sensitive topic to address it in the most effective way possible within the context of oil and gas development and production. The purpose, in my mind, of this rulemaking is in large part to address a specific potential use of PFAS that is not addressed as part of the larger PFAS problem from other sources. Ultimately, we arrive at a proposal that includes a ban on the use of PFAS in completions activities, require certification that qualifying PFAS were not used by operators, creates a reporting and disclosure requirement to the OCD in the event of potential contamination, and trigger necessary investigations and remediation under existing commission rules. Today we'll be, or during the course of this hearing, we will be putting forth the testimony of 3 witnesses, Dr. Court Sandow and Dr. Eric Martin. Will respectively address the chemistry and toxicology of PFAS, the foundation for the division's proposed rule definition of PFAS, and the role and limits of PFAS testing methodologies. And then Mr. Brandon Powell, Deputy Director of the OCD, will provide testimony to explain the remaining structure of OCD's proposal and the reasons why OCD is recommending changes to the latest petition to allow the core elements of this petition to work within the existing statutory framework and resource limitations of the Oil Conservation Division. At the end of this hearing, we believe that the record will show that PFAS chemicals, as proposed to be defined by OCD, warrant regulation as to their use in oil and gas, due to the consensus that at least some of the chemicals are harmful to human health. In reliance on industry representation that PFAS are not currently used, it is not necessary for use in completions operations, and the prohibition on their use achieves the goals of protecting public health and the environment without harming industry. The scope of the definition in our proposal is appropriate regardless of history or current use of PFAS, as chemicals falling under the proposed definition have the potential for future use. So this prohibition on their use and structure proposed by the division is forward-looking. We believe that the record will show that there are possible pathways from completion liquids to groundwater. So the proposal is warranted and addresses a real, if potential or debated to its extent, problem. We do expect extensive debate and disagreement on a periphery of terms, or at least the most robustly stated conclusions. But I believe that the record should fairly review a consensus on those core issues, that PFAS can be harmful to human health, use of PFAS in oil and gas completions activities creates at least a potential pathway of exposure to humans, that prohibiting use in completions will not materially detriment oil and gas operations, and that oil and gas operations may proceed in the future effectively without the use of PFAS. I would like to clarify a few things that we do not believe will be shown in the record or that the division disagrees with. Full public disclosures of proprietary information are not supported by the OCD at this time in observance of the Uniform Trade Secrets Act. OCD does not take a position on the veracity of such a public policy, but this, we believe, would necessitate a legislative update. In addition to the Uniform Trade Secrets Act, one statute of particular concern to the division is that trade secrets within the possession of the division, if held and marked identified as trade secrets, are accepted from the Inspection of Public Records Act. There is a potential that PFAS could be addressed as part of a groundwater discharge permit under the Water Quality Act. However, that's a very small component of OCD's purview. And we believe that the current structure of the petition, as we proposed, anticipates OCD addressing any such impacts under Part 29 or 30, which are promulgated under the authority of the Oil and Gas Act. So as stated earlier, we do, in reference to council statements, we do not believe that the bulk of the proposal is going to fall under the exception as stated, as referenced in the other statute. OCD's proposal does not contemplate a definition inclusive of all possible PFAS chemicals. And there's a very practical reason for this, that until OCD is able to test or order testing to verify for any particular chemical, OCD cannot possibly enforce a prohibition. So if there is a rule promulgated that prohibits the use of an expansive list of potentially thousands of chemical compounds, OCD will have no means or ability until testing methodologies are updated to actually verify the existence or the amounts of those chemical compounds. And so you will see as we work through the division's proposal that we have identified a definition of PFAS generally that is more broad than that proposed in the red line from NMOGA, but is limited to existing and future updates to testing methodologies. There's a number of things that this rule, that this hearing will not address, which is that it will not change the way that the division addresses releases or groundwater abatement once those occur. It will not address potential surface uses of PFAS, and it does not address air quality or PFAS from non-oil and gas sources. In terms of the other party proposals, OCD does not support a ban on the use of all proprietary chemicals. This relates to the Uniform Trade Secret Act, but also, as will be explained, there are numerous other proprietary or trade secret compounds that we do not believe will be supported by the record necessary to support a ban that have nothing to do with PFAS. So essentially, this proposal of banning the use of anything that's listed as proprietary would ban the use of chemicals that we're not talking about during this hearing from a perspective of human health impacts. OCD does not concede NMOGA's generation versus disposition argument. There is a legal distinction to debate there, but within the context of this petition's language, I don't see a difference in effect. And I'm hoping, I do not believe that this needs to be litigated, simply clarified in terms of discussing the petition. Further, OCD cannot support proposed language that elevates the requisite intent of operators to an unreasonable degree. Essentially, operators must be held responsible for additives in completions fluids. This is an important distinction because OCD's authority does not extend to, for instance, chemical manufacturers outside of the oil and gas industry. So to effectively regulate PFAS, operators must be held responsible for additives that are included by manufacturers and used by the operator, whether or not the operator at the time took the necessary steps to know of their use. So essentially creating an impetus for operators to require that information so that they know exactly what they are certifying that they're not using. The rule must require operators to obtain, as I said, necessary details related to any completion additive. Now, the nuance here, the flip side of this is that it is not OCD's intent to hold operators accountable for PFAS contamination that originates from sources outside of oil and gas. And that is a very complicated proposition, potentially. I think it will become necessary during this hearing to clarify the rule's proposed coverage of potential coverage of drilling fluids, which we will address, and I will notice separately through rebuttal testimony from Mr. Powell. I think that this contemplates the necessary modifications to sections of the rule, to different sections of the rule. Depending on exactly how it's proposed for a PFAS ban to address use in drilling fluids, we will need to clarify that the structure is appropriately noticed and appropriate outgrowth of the current petition. Additionally, there are other safeguards related to the drilling processes, drilling fluids, and materials that are used that Mr. Powell is able to explain. So drilling fluids and references in the Wildlife Guardian's testimony to downhole operations was not really contemplated by OCD in review of the revised petition due to the use of completions and recompletions language. But I think it's something that we're going to need to talk about as we move through the hearing. We will continue to work with the parties during this hearing to address those concerns, and ultimately it's OCD's understanding that fluids used while drilling through freshwater zones are already limited under OCD rule and practice, which we can address at a later time. So ultimately, when you look at the division's red line, OCD proposes a definition of PFAS that will automatically grow with the scientific consensus and testing methods available, which will allow OCD to actually and effectively enforce the rule. We do support, the petition does support a triggered reporting mechanism where complete information is disclosed to OCD. So in the event of like a loss of containment from a casing failure, for instance, full chemical disclosures would be required under our proposal to the OCD. So that's the line we're drawing where we don't believe that there's authority to require that disclosure publicly. That has to be a legislative mandate. But in terms of effective enforcement, we do believe that that information in specific circumstances can and should be held by the division absent a legislative amendment. We believe OCD's authority allows us to require that disclosure. Further, as a rulemaking petition rather than a legislative proposal, it's imperative that the commission adopt a version of the rule that's effective given the existing statutory authority and the resources of the division, as this commission, as you know, is not authorized and enabled to expand either the authority or those resources. We believe that OCD's red line proposal achieves each of these goals and should be adopted with any modifications and clarifications deemed necessary and appropriate by the commission at the summation of the hearing. Thank you.
Thank you, Mr. Tremaine. Let's see, Mr. Maxwell, do you have an opening statement?
Your Honor, I would reserve my time.
All right, thank you very much. Let's see, is the EOG representative on? No. All right, they can reserve if they'd like. And to NMOGA, Ms. Mulcahy.
Good afternoon. Thank you, Madam Hearing Officer. Thank you to the Commission. Thank you to the other parties in this matter, as well as all of the folks that provided public comment this morning. We appreciate everyone's time. I would start by saying NMOGA supports prohibiting intentionally added perfluoral and polyfluoroalkyl substances, PFAS, to the chemical additives used in hydraulic fracturing fluids in the completion or recompletion of oil and gas wells. We want to make that position very clear. NMOGA supports the proposed regulations where they are consistent with 1, up-to-date scientific standards, data, and understandings of PFAS. 2, where they are technically feasible and technically correct. And 3, consistent with the Commission's statutory authority. As NMOGA will demonstrate, based on the disclosures in FRAC Focus, the oil and gas industry has already discontinued using 2 PFAS compounds historically used in downhole operations. The Physicians for Social Responsibility report on New Mexico identified 2 specific PFAS compounds that were historically used downhole in New Mexico. These 2 compounds are 1, PTFE, which has not been used since 2020. 2, fluoroalkyl alcohol substituted polyethylene glycol. My Lord, is that a mouthful? We are going to call that FPEG for short. FPEG has not been used in operations in New Mexico since 2015. NMOGA has proposed a definition of PFAS in this rulemaking. NMOGA proposes the following definition of PFAS, quote, substances with 2 or more fully fluorinated carbon atoms, end quote. NMOGA proposed this definition for 2 reasons. 1, it is the definition of PFAS that the Environmental Protection Agency, the agency tasked with regulating the manufacture, import, and control of PFAS and PFAS-containing substances, adopted under the Toxic Substances Control Act, or TSCA. This is the TSCA definition. Second, this definition is both tangible and executionable and enforceable. No analytical method currently exists that can analyze for a single fluorinated carbon compound like WEG and New Energy Economy proposes. Not a single analytical method. Without any method to verify compliance through analytical sampling, any definition of PFAS that contains a single fluorinated carbon atom would be unenforceable. In the alternative, NMOGA supports the definition of PFAS propounded by the division. While the division's definition does include a single fluorinated carbon atom, it also specifically identifies analytical methods to be used for compliance. Currently, these analytical methods all require 2 or more fully fluorinated carbon atoms, which makes the division's proposed definition tangible, executable, and enforceable. Because, as I already mentioned, WEG's definition has no analytical method that exists today. At the same time, the division's definition, while including a single fluorinated carbon atom, defines PFAS in a manner to allow it to be a living definition. That is, as the scientific understanding and analytical capabilities of PFAS advance in the future, analytical methods can be added to this definition. Relatedly, NMOGA has also proposed a definition for, quote, intentionally added PFAS. NMOGA proposes the following definition: PFAS that are deliberately added during the manufacture of a chemical product to serve an intended function in the final product. NMOGA's proposal to include a definition of intentionally added PFAS is consistent with those statutes and regulations passed by all states that have banned the use of PFAS in various industrial applications. These states are identified in Wild Earth Guardians. I'll call them WEG or Guardians, Exhibit 8. Each of these states in Wild Earth Guardians Exhibit 8 have included a definition of intentionally added PFAS. Every one of them. NMOGA has included the term intentionally added PFAS with its proposed revisions to account for the numerous potential sources of PFAS that are unrelated to oil and gas operations, but may nonetheless result in PFAS being present in the environment. These sources can include septic systems, treated wastewater from wastewater treatment plants, biosolids used for agriculture, consumer textiles like this jacket that I'm wearing, firefighting foams, and many other sources. The division has proposed a similar backstop in its red line revisions to account for PFAS that may be in the environment and that is unrelated to oil and gas operations. Any regulations that the Commission adopts to prohibit the use of PFAS compounds in hydraulic fracturing fluid additives must be tangible, executable, and enforceable. That means the regulation needs to be clear so that it can be easily implemented by the division and followed by the industry. The regulation must be science-based, so the rule accurately reflects the actual analytical capabilities to sample for PFAS compounds. And the regulation must be flexible to keep pace with advancement in scientific understandings of and analytical capabilities related to PFAS. Furthermore, any final rule also needs to be tailored to the PFAS that has been documented in the oil and gas industry. So 1, the rule is not overly broad in scope. 2, stays within the Commission's authority. And 3, provides a predictable regulatory framework that can actually be implemented. In addition to supporting the ban on PFAS intentionally added to hydraulic fracture fluids, NMOGA also supports requiring oil and gas operators to certify that no PFAS-containing fluids have been used in the fracturing of an oil and gas well. To implement this rule, NMOGA urges the Commission to continue to use FRAC Focus as the platform for industry chemical disclosures. It is a proven framework for managing these disclosures. It is a tried and true system. There is simply no good reason to abandon it. On the issue of disclosures, NMOGA cannot support either 1, petitioner's proposal to provide hydraulic fracturing disclosures to a litany of individuals outside of and in addition to the mandated disclosures in FRAC Focus. So to be clear, NMOGA has no issue with continuing to make disclosures in FRAC Focus, but the additional disclosures that WEG proposes to a whole litany of individuals is ridiculous. Second, petitioner's proposal to wholly ban the use of any chemicals downhole that are not fully disclosed in FRAC Focus is something NMOGA cannot agree to. Petitioner has proposed requiring additional disclosures outside of FRAC Focus to building owners, area residents, tribal members, schools, government actors, public water systems administrators, and many, many other individuals and entities. As Dr. Janet Anderson has testified in her pre-filed written direct testimony, petitioner's proposal to provide scattershot disclosures to this litany of individuals and entities without any context and whom lack the necessary expertise to understand and interpret such disclosures is contrary to standard risk communication best practices utilized by toxicologists such as Dr. Anderson. Such scattershot disclosures can and have caused more harm than good in communities, as Dr. Anderson also testifies. New Mexico law recognizes the importance, Likewise, petitioner's proposal to ban the use of any undisclosed chemicals violates New Mexico's law and public policy. New Mexico's law recognizes the importance of maintaining the confidentiality of valuable commercial information, also known as trade secrets. There has been much discussion already here today about trade secrets. This morning, Mr. Rubin mentioned Section 74.615, which is the statutory provision that applies to the Water Quality Control Commission. 74.615 does not apply in this rulemaking because the commission is not acting pursuant to the Water Quality Act. Additionally, even if you were to assume that this commission was acting pursuant to its constituent Water Quality Act authority, the plain language of 74.615 demonstrates both a strong public policy and legal protections for trade secrets. In fact, that statute continues to protect trade secrets. New Mexico's Uniform Trade Secrets Act also protects trade secrets from being publicly disclosed. The prohibition against public disclosure of trade secrets has been codified by statute in this state and has been case law for at least 35 years. New Mexico law and public policy on trade secrets apply equally, whether the trade secreted information is a manufacturing process, software program, or chemical additive for hydraulic fracturing. In fact, the term used by 573A2 for a trade secret includes information, a formula, a pattern, a compilation, a program, a device, a method, a technique, or a process. It is quite broad. Petitioner's proposed rule that requires the full disclosure of trade secreted fracturing fluids or the inability to use those fluids downhole runs afoul of New Mexico law and public policy. It seeks to prohibit the use of valuable, useful, and entirely legal chemical additives that have nothing to do with PFAS just because the chemical is trade secreted. Petitioners and their supporters are making the exact same arguments here today that the Commission heard back in 2011 when it first adopted the hydraulic fracturing disclosure rule, and again in 2017 when the Commission updated the rule to adopt the frac focus form. The only difference now is that petitioners are pointing to Colorado and California, which recently made legislative changes, not regulatory changes, legislative changes to address the disclosure of chemicals in oil and gas operations. In our pre-hearing statement on page 8, NMOGA discusses why a legislative process is different from a rulemaking process and why that matters. Here, the Commission has no legal authority to codify Colorado's legislative approach into this regulatory framework. It makes no sense and would be contrary to public policy to prohibit downhole use of effective hydraulic fracturing chemicals just because they are not publicly disclosed in their entirety. Nevertheless, in its red lines to Wild Earth's amended regulations, NMOGA has proposed a process by which operators could fully disclose all chemicals to the division in the event that such disclosure is needed. I would also point the Commission to 19.15.16.19B2, where the Commission has adopted by reference 29 CFR 1910.1200. Those are the hazard communication regulations from OSHA. Under the OSHA regulations at 1910.1200 I2, there is already a process in place whereby healthcare providers and first responders can obtain full chemical disclosures. That exists already in the rules today. NMOGA's proposal to do a full disclosure to the division strikes the right balance between continued protection of trade secrets under New Mexico law, while also providing regulators with all information when and if needed. Finally, NMOGA has provided a full response to the proposed rulemaking here today, including our legal arguments and our pre-hearing statement. NMOGA has also included its modifications to the proposed rule in red line strikeout format in NMOGA Exhibit A. Those documents appear in this giant binder that we have provided to the commission and the hearing officer. As the commission will see in these documents, NMOGA is substantially in agreement with the division over 1, what portion of the rules should be adopted, what portion should be rejected, and how the rules should be modified to make them tangible, executable, and enforceable. I will not go over every legal argument or technical position in detail that we have provided in our pre-hearing statement. But I do want to draw the commission's attention to a few important considerations that are necessary to bear in mind as you consider the testimony over the coming days. First, it is important to keep in mind that the commission has no statutory authority over the quote generation of non-domestic waste, only the disposition of non-domestic waste as enumerated in the Oil and Gas Act. Petitioners seek to prohibit the quote generation of PFAS contaminated produced water and non-domestic waste. If indeed the commission had this authority, it could have been included here expressly in 70-2-12, where, such as in other statutes governing oil and gas regulations, specifically
Brittany Hall, can you hear us?
yes.
Yes. Okay, we're back on. Sorry, Ms. Mulcahy.
No problem. Section 72-12B15 provides the commission with authority to, quote, regulate the disposition, handling, transport, storage, recycling, treatment, and disposal of produced water. It makes no mention or enumeration of generation. Likewise, section 70-2-12B21 empowers the commission to regulate the disposition of non-domestic waste resulting from the exploration, development, or storage of crude oil or natural gas to protect public health and the environment. Again, these enumerated powers are specific and they are intentional. Second, and relatedly, petitioners attempt to conflate produced water and non-domestic waste with one another. That is both procedurally and substantively improper. Produced water and non-domestic waste are defined by statute. Under both the division's regulations and the Produced Water Act, produced water is defined as, quote, an incidental byproduct from drilling for or the production of oil and gas, end quote. Non-domestic waste, which is statutorily defined at 74-3-43A, is, quote, waste associated with the exploration, development, production, transportation, storage, treatment, or refinement of crude oil, natural gas, and carbon dioxide gas, but does not include produced water, end quote.
Wrap up, Ms. McCahey.
Third, as I mentioned in this opening statement, NMOGA supports a prohibition on intentionally added PFAS in the completion or recompletion of wells. NMOGA's Exhibit A contains red lines to WEG's proposed amendments. NMOGA's Exhibit D contains the written direct testimony of Dr. Stephen Richardson, PE, PENG, and PhD. NMOGA's Exhibit E contains the written direct testimony of Dr. Janet Anderson, PhD, toxicology. Together with its pre-hearing statement, these exhibits provide NMOGA's detailed, science-based revisions to Wild Earth Guardian's proposed regulatory amendments. NMOGA and its technical experts have carefully considered and has agreed with Wild Earth's proposed amendments where they are consistent with up-to-date scientific standards, technically feasible and technically correct, and consistent with the Commission's authority. At the end of the day, and at the end of this rulemaking, if there is no way to ensure regulatory compliance through sampling and analysis, then any regulations banning the use of PFAS in oil and gas operations are essentially meaningless. Thank you.
All right. Thank you, Ms. Mulcahy. Can we turn now to our first witness, Mr. Horwat?
Wild Earth Guardians calls Dusty Horwat.
Terrific. Go there. Do you swear or affirm that you will tell the truth, Mr. Horwat?
Yeah.
Thank you very much. Go ahead, Mr. Davis.
Good afternoon, Mr. Horwat. Could you please state and spell your name for the record?
Yes, it's Dusty, D-U-S-T-Y, Horwit, H-O-R-W-I-T-T.
Did you prepare direct testimony on behalf of Wild Earth Guardians in this matter?
Yes,
And that is Wild Earth Guardians Exhibit 10?
yes,
Did you prepare rebuttal testimony in this matter?
yes,
And that is Wild Earth Guardians Exhibit 94.
yes,
Do you have any changes to that written testimony?
no,
Did you review and rely on any documents to prepare your testimony?
yes,
Are those the documents that are in Wild Earth Guardians Exhibits 11 through 55?
yes,
And your CV is also an exhibit to your testimony?
yes,
Is that Wild Earth Guardians Exhibit 9?
yes,
Is your written testimony direct and rebuttal, true and accurate to the best of your knowledge?
yes,
Do you adopt your written direct and written rebuttal at Wild Earth Guardians Exhibits 10 and 94 as your sworn testimony today?
yes,
With that, Madam Hearing Officer, I would move for the admission of Wild Earth Guardians Exhibits 9 through 55 and Wild Earth Guardian Exhibit 94.
Let me ask if there are objections from the other parties. Please
Yes.
just speak up. Ms. Mulcahy?
Yes, Madam Hearing Officer, we have an objection to parts of Exhibit 94. And I guess right now I will not only make an objection to the admission of parts of Exhibit 94, I would also make an oral motion in limine to exclude parts of Exhibit 94. And I have highlighted those parts here on my screen, which I'm willing and able to share if it's easier to visualize it that way.
All right. Sheila, would you allow Ms. Mulcahy to screen share, please?
Yes, she should be allowed to share.
If we could pause for a moment, we're up here looking for Exhibit 90.
Okay. We're going to take just a moment here to settle ourselves.
Found it, thank you.
Go ahead, Ms. Mulcahy.
Thank you, Madam Hearing Officer. NMOGA would object to and also would seek to exclude certain comments in Mr. Horowitz's rebuttal testimony. I have highlighted those here in red on the screen, and we seek to exclude them because they are conclusions about the chemistry and toxicology of PFAS that Mr. Horowitz makes in this testimony. And I'm looking at WEG Exhibit 9. Mr. Horowitz is an attorney and an advocate. He has no scientific, technical, or engineering training. He is not qualified to opine on whether or not certain PFAS are exceptionally toxic. He is not qualified to opine on the chemistry of these PFAS. He is not qualified to opine on exposure pathways to these PFAS and what, if any, might be the results of any such exposures. I'm happy to go line by line here, sharing my screen to demonstrate what it is that we seek to exclude.
Okay, let me first ask Mr. Davis for a more general response to your objection. I do remember that Mr. Horowitz is an attorney, and I understand that he has a lot of research in his background into this highly specialized area, and yet we do have to make sure that we don't have attorneys testifying as chemical chemists.
Yeah, in addition to that, I'll just add on that if we look at the citations to Mr. Horowitz's testimony, he relies on reliable and publicly available sources. And some of those are actually the drinking water regulations. So any argument that NMOGA has that he cannot simply compile this information from these publicly available sources and apply them to his testimony regarding regulations, legal loopholes, would just go to the weight. But I don't think that that makes it inadmissible at all. It's certainly relevant, which is the standard for admission in this proceeding. And Mr. Horowitz has already been qualified as a technical expert. And so, again, I would just ask the commission to take a look at what he cited and then make a determination based on how much weight you believe that deserves.
Right. So I'm going to stay with you there, Mr. Davis. For example, on page 2, the part here that Ms. Mulcahy has highlighted in pink, PFAS are exceptionally toxic. I don't see a citation right there. Are there? Yeah, go ahead.
There are many citations under that heading, and if we in order to move this process along, we're more than happy to strike his heading.
So, Ms. Mulcahy, let me ask you then, to the extent the commission were to be advised clearly that Mr. Horowitz is a lawyer, that anything that resembles a conclusion that would require a chemistry degree, for example, to reach would not be his own, but would be made only in reliance on the work of others. And to the extent those others are included by citation in the materials, do you think that would remedy it?
Thank you, Madam Hearing Officer. No, I don't believe it would remedy it. First of all, it's not just merely the heading here. That's just one example that I've provided. But there are numerous other examples in this document. And I would also say that two things in response to Mr. Davis. Mr. Horowitz has not been identified as a technical expert. He has been identified as a technical witness. And to the extent that he has relied on other scientific statements in this paper, again, he is not a scientific expert. So he has no authority, even under a relaxed evidentiary standard, to rely on those documents because he himself is not a technical expert in those fields. For example, here on page 2, lines 15 through 18, he opines on the need for greater toxicity studies because there is significant toxicological data that exists that puts the public at risk. And these PFAS are exceptionally toxic. He is not qualified to make that statement. Neither does he cite to any authority for making that statement. And so to the extent that he goes through this paper, through this rebuttal testimony, which there are numerous instances which I've highlighted here about, human carcinogens and analogizing PFAS to other chemicals and why they're similar or different than other chemicals. He is not qualified to make those statements, Madam Hearing Officer.
Part of my challenge, of course, is that I walked through this very quickly today. So we received it this morning. So, Mr. Davis, I share Ms. Mulcahy's concern that, again, I certainly recognized, even in our pre-hearing conference last Wednesday, that Mr. Horwit had background and expertise in research, right, in legal research in this area of law. That's how I understood he was being offered, if you will, as a technical witness last week. This just seems different to me, obviously. It seems different to Ms. Mulcahy as well. The statements that seem to me typically would rely on expertise in chemistry or toxicology, for example.
If I could offer a quick response to that.
Please.
First of all, the statement that's highlighted in purple, I believe is something that Namoga's own witnesses acknowledge. So that, combined with the fact that we are in front of a commission that by statute must have expertise in the matters over which they regulate, I believe the commission's absolutely qualified to take a look at this testimony, look at the citations to things like the Federal Register, federal government websites, scientific studies, and make a determination based on weight. We're not protecting a lay jury here. And again, I think that the commission's more than capable of reading this and assigning weight. But Mr. Horwit does have to have some facts to which he can apply these regulations to show the gaps that exist in chemical reporting and why that's important.
Okay. Is there any other party who would like to offer a comment on this objection? I forgot to ask. No? Okay.
If I may.
Yes.
Madam Hearing Officer, regardless of whether Namoga agrees with some of these statements or not, does not still qualify Mr. Horowitz to speak on them. And certainly the Namoga witnesses that have agreed with some of these statements are technically qualified. They're PhD toxicologists working specifically on PFAS. They are chemists working specifically on PFAS. And regardless of the commission's own amazing experience and expertise, this witness still must be qualified in and of himself. And like I stated originally, Mr. Horowitz cannot rely on these articles because even under the most relaxed evidentiary standards, he still has to have the technical expertise to independently analyze and understand and make his own conclusions about these very scientific topics, including toxicology, chemistry, exposure pathways. He is not qualified to do that. Otherwise, it's all just hearsay. It's all hearsay.
I'll just add that hearsay is not something that makes anything inadmissible in this proceeding.
Yeah,
the rules of evidence don't apply.
Yeah, no, I understand, Mr. Davis. The rules of evidence do not apply, and this is a more sophisticated body. Uh, I say that with affection than your typical jury. Sorry. Um, uh, but, but as I think I said last Wednesday, I really do try to take my role seriously as something of a gatekeeper, even if that gate is full of holes, around making sure that what the commission is focusing on and has before it can be relied upon to make their decision. That's my focus, and I'm concerned about some of the rebuttal testimony. I wasn't concerned about the direct testimony, but some of this rebuttal testimony raises concerns for me. Having said that, I don't know that it is helpful at this moment to either strike it all or accept it all, or to walk through paragraph by paragraph. I don't know that that's helpful either. So,
Madam Hearing Officer?
yes,
if I may?
Commissioner Bloom. Yeah.
Yes. So as a commission, could we be in a position then where we can only hear from scientific experts and there can be no consensus around anything that any PFAS is toxic unless we hear it from a scientific expert?
So let me just offer an example that we talked about last Wednesday. It was a hearing I did a very long time ago in Eunice, New Mexico. There was a man offered as a witness to talk about karst near the LES plant proposed. And there was an objection because he had a degree in geography, the landscape, if you will, not geology. And so the way I handled that and the way, let me put it this way, the Court of Appeals, I think, tends to prefer administrative bodies and agencies to handle it, is to accept it as part of an offer of proof so that it is in the record. That is to say, anyone reviewing the record can actually see what was offered. I mean, it's not going to be stricken as in, let's tear it up. But a warning, if you will, or a caution that relying on what appears to be a toxicological conclusion reached by a lawyer is not going to form a great basis for a final decision for you. Okay. Legal analysis, great. Toxicological conclusions, you ought to hear that from a toxicologist or a chemist. That's all. So let's do it this way. Ms. Mulcahy, please, on your cross-examination of Mr. Horwit, draw a few lines there in terms of his background or experience. And for now, I think we have this caution here. And I won't admit 94 without reservation for the moment. Unless we have further conversations about it, I'll accept it as part of an offer of proof. So please assume that it's in. Please assume that we haven't yet, obviously, we haven't yet walked through it line by line. I would like to keep going. So where were we? Are there objections to any of the other exhibits that were offered? Just 94? Okay. So 94 is accepted for the moment. It's part of an offer of proof, and all the other exhibits. Mr. Davis, would you repeat the numbers, please? 9 through
55.
55 and 94, yes?
Correct.
Thank you. So 9 through 55 are admitted. 94 is accepted as part of an offer of proof and may be the subject of additional discussion. All right. Is there anything else, Mr. Davis?
The witness is available for questions from the commission and the parties.
Thank you. I'm going to start with the parties, and I'm going to go in the order of presentation. And then I will go to the commissioners. So again, we don't have any E. It would be the division's turn to ask questions of Mr. Horwitz if they have them.
Madam Hearing Examiner, I'm sorry, and I'm not sure we discussed this on Wednesday or not, and I may be remembering from the hearings over the summer, but I was under the impression that we would cross in reverse order to presentation. So I just wanted to get a clarification on what the order of cross will be.
All right. How do the other council feel about that?
We did discuss it at the procedural hearing on the 6th, and we said we would go in the order that the parties proceed, but we're happy. I just conferred with Mr. Tremaine, and he said he's fine if Namoga goes. I don't mean to step in front of any other party. If there's another party that would like to go, I'm happy to wait.
All right. Any other comments? I see your camera on, Mr. Maxwell. Do you have a comment on the order in which cross is held?
I do not.
Okay, thank you. Go ahead, Ms. Mulcahy. We can go in reverse order.
Thank you. Thank you, Mr. Horowitz, for being here. We appreciate it. Mr. Horowitz, your professional experience, if I'm not mistaken, is listed in WEG Exhibit 9. Is that correct?
I believe so.
Okay. And Mr. Horowitz, looking at WEG Exhibit 9, you are an advocate you've spent your career advocating against oil and gas. Is that correct?
I've spent my career advocating to try to protect communities from pollution caused by oil and gas.
So the answer is yes, then. Thank you.
I wouldn't characterize it that way, but it's up to you.
And Mr. Horowitz, you are not a chemist, correct?
That's right.
And Mr. Horowitz, you are not a chemical engineer, correct?
That's correct.
And Mr. Horowitz, you are not a toxicologist, correct?
That's correct.
And Mr. Horowitz, you have no scientific education, is that correct?
I don't have a degree in science, but I have taken multiple courses in science in college.
You do not have a degree in engineering, correct?
That's right.
Nothing further. Thank you.
All right, thank you. Mr. Maxwell, do you have questions of Mr. Horowitz?
Your Honor, I do not. Thank you.
Thank you. Mr. Tremaine, do you have questions of Mr. Horowitz?
No further questions.
Right. Mr. Davis, and he redirect before I go to the commission.
I do not have any redirect.
All right.
Thank you.
Thank you. Mr. Chair, do you have questions of this witness?
I do not.
Okay. Commissioner Bloom?
Madam Hearing Officer, thank you. Can y'all hear me? It's live? Yeah, okay. Probably screaming. Yesterday at this time, I'm sure I clearly remembered Mr. Horowitz's testimony and the issues that he spoke to. At this point, having heard a little bit from all sides, Mr. Horowitz, if you could give us maybe a 2-minute summary of the issues you spoke to. I do have some questions. I'm just not sure which person to ask them of, so.
I'm sorry, the issues I spoke to?
The issues on which you provided testimony.
Oh, yes. Yes. So basically, we are concerned about the use of PFAS in oil and gas operations in New Mexico. The organization that I wrote a report for, Physicians for Social Responsibility, found that over about a 10-year period, oil and gas companies have used 2 types of PFAS, as Ms. Mulcahy mentioned, in New Mexico, PTFE, and I'll try to attempt this one also, fluoroalkyl alcohol, substituted polyethylene glycol, I think. And we are concerned that those types of PFAS could pose toxic risks given the evidence we know about the types of PFAS that have been studied for toxicity, which have been found to have a variety of health harms, including cancer, preeclampsia, which is a dangerous condition for pregnant women, low birth weight babies, and others. We're also concerned that there are many, many, many examples over this 10-year period, 2013 to 2022, of oil and gas operators in New Mexico using at least one trade secret chemical in their oil and gas wells, which could be additional PFAS. We counted 8,000 some wells out of a total of 9,000 wells we examined in that period. And so given the extreme toxicity of the PFAS that have been studied for toxicity, we believe it's very important to have full disclosure of the chemicals going into oil and gas wells in New Mexico so that the public can know the extent of the use of PFAS. And we think it's very important to have a prohibition on PFAS. I'll just add, there are two other pathways through which oil and gas companies in New Mexico could use PFAS without disclosing them to the public. And one is that under New Mexico's law, companies have to disclose to the public only chemicals they use in hydraulic fracturing, but not the chemicals they use in other stages or methods of oil and gas production, like drilling that precedes fracking, chemical flooding, anything else. And so chemicals that could be PFAS could be used in those other stages and methods. And then New Mexico's law also says that disclosure does not have to extend beyond what's in safety data sheets related to the chemical products. And what we've found in our research is that those safety data sheets, at least in other states where we've been able to examine them, often do not disclose the full list of chemicals in the chemical products. So in other words, a company might use a chemical product in an oil and gas well. The safety data sheet could say something like, this product contains 5% methanol and 25% water, and that's it. And the 75% of the ingredients could be missing. And we've seen multiple data sheets like that. So if that's the basis for the disclosure, it could be incomplete, and there could be PFAS used without being disclosed.
Okay, thank you, Mr. Horowitz. Mr. Horowitz and Mr. Davis, I do have some questions for y'all, and if you feel that there's somebody coming after you that would be more appropriate to answer that, you just please let us know. Mr. Horowitz, are you comfortable speaking to some of the public disclosure related issues?
I think so.
Okay. And I'll ask this of Namoga's witness too, but we heard, I believe from Namoga today, that PTFE and FPEG have not been used in New Mexico in a number of years. But how do we know something like that with certainty when there are protections for proprietary information? How do we actually know what has gone down the wellbore in a frac job?
Yeah, we don't know that with certainty. We examined in our report the records listed with Frac Focus, which at least some of the witnesses mentioned that is the repository, the legally required repository for fracking chemicals for the state of New Mexico. And we also looked at the disclosures to the state of New Mexico, which the disclosures used to be made under the law to the state rather than to Frac Focus, rather than solely to Frac Focus. And then at a certain point, I can't remember exactly what year, there was a switch so that the fracking chemicals are disclosed only to Frac Focus. But that's the universe of records we looked at. And it is correct that the disclosed uses of PTFE and I'll call it PEG stopped at a certain point. I think PTFE did stop in 2020. The other one stopped in, I think it was 2015. But we cannot be confident that that means that those types of PFAS were not used beyond those dates, or that other types of PFAS were not used during that 10-year period we looked at or beyond those dates because of the gaps in disclosure that I mentioned.
Okay, thank you. And then is part of Wild Earth Guardian's proposal, you would have a much more robust disclosure regimen, including people living nearby, police departments, fire departments, the BLM, the state land office. I'm not sure, and I might have missed it, but how would the public be advised in these cases?
You mean how would they receive those disclosures? I think perhaps Wild Earth Guardians could speak to that directly. My understanding, having looked at multiple different state disclosure regimes, I recall that in California, they have a similar requirement that certain parties that live close to the fracking operation must receive chemical disclosure directly. And I believe they do that by certified mail. I'd have to double check on that. And let me just add that I do think it's important for people living close to the oil and gas wells to have that type of disclosure, especially if there were an emergency situation. As Ms. Mulcahy said, there are some avenues for first responders to access trade secret information, which may not be available for certain wells. However, based on my conversation with a longtime first responder, time is of the essence in those situations, and having that data on hand would be very important, so that a first responder would not have to contact a federal agency and perhaps wait some period of time to get that information. And for people who are not first responders, it's also important to have the information as soon as possible so that people can make decisions about whether they want to ask for water testing for themselves or for their community, whether they want to confer with scientific experts to determine if certain chemicals do pose a risk that are being used nearby. So there's several reasons I think it's important.
It looks like Mr. Davis wanted to weigh in, and I had one more follow-up regarding frac focus, but Mr. Davis.
Yeah, I'll just say that the proposed rule does not require any method for notification, nor does it restrict any method of notification.
Would then this be left to the OCD to determine, or do we need to determine that in the course of this hearing?
I would say that the division could do that. If we determine it in the course of this hearing, I'm certainly open to discussing that with the parties.
Very good. And Mr. Horowitz, do you know, in the case that a company invokes their proprietary information, I guess status under frac focus, who has that information of what was used in that frac job? Is it just the company, or is it filed and held aside by frac focus? Does OCD have that information? Do you know?
I have not seen any requirement that anybody besides the company has that information. And that's in contrast to Pennsylvania, which is the state that leaps to mind, which requires trade secret information to be filed with the state. So the state of Pennsylvania has fracking trade secret information, at least for, I think it's horizontal gas wells, and they keep that, but that's not disclosed to the public.
So, Mr. Horowitz, we've seen a lot of M&A activity, merger and acquisition activity in the Permian Basin in the last decade plus. I don't know that too many people would imagine that ending anytime soon. I guess, does this raise questions for you about the longevity or the ability to get that information from a company when it hasn't been filed with the state or Frac Focus or a third party that has an enduring presence rather than a company that can be swallowed up by another one, or frankly go out of business, which is something I'm here from the land office. That's something that we deal with more than you'd imagine. Complete loss of records, both through hacking, companies shutting down. We've seen all of that. Is that a concern?
Yes, it is a concern. And I would add that under Colorado's newly enacted law that requires full disclosure of chemicals used underground in oil and gas wells, all of that chemical information has to be shared with the state. Although, as Mr. Davis indicated, when the chemical information is disclosed to the public, it's disclosed in a way that is just a list of individual chemicals that would make it difficult for anybody to be able to link those chemicals back to particular chemical products that went into the well. And that's a type of chemical disclosure that has been recommended at least since 2014, when a panel of the U.S. Department of Energy recommended that type of disclosure for fracking chemicals as a way to make the public fully informed of what kind of chemicals are going into oil and gas wells without creating undue risks for the oil and gas companies that their intellectual property could be stolen by a competitor.
A different angle on this, perhaps, and this might be more of a question for Mr. Davis or someone else, or maybe it's irrelevant, but I mean, what do you hope that the public gains from this more widespread disclosure? I think all of us get a lot of mail sometimes that we didn't ask for. If it was a certified mail arriving in our boxes, we're someone that lives in the oil patch and we're receiving a lot of this. What do we do with it? How do we handle it? Would it help a fire department if the city, say of Carlsbad, receives 400 notifications a year? We don't know that that's going to be organized in any helpful way. I'm wondering if there's another way to make information more accessible. I just kind of an open question there.
That's a good question. I think for an institution like a fire department, they could receive, as you suggested, multiple certification or multiple lists of chemicals if they cover the territory involving multiple oil and gas wells. I think it would be in their interest to keep those on file in some kind of organized way. As far as individuals, I think it would be possibly unlikely that an individual would live near, hundreds of wells or dozens of wells. I think it would be a manageable amount of information, and people can decide what to do with that, if they want to follow up on it or not, but at least they would have access to it and they would know that there are chemicals being used close to them and what those chemicals are.
Yeah. Commissioner Bloom, I'd just like to add that Dr. David Brown will be testifying as well in this and in this proceeding. He is a public health expert who has dealt with these disclosure issues in Pennsylvania. So just in terms of the importance of that, why it might be important to disclose, I would ask you to direct some of those questions to him. And not sure how the rest of this is going, but I think we may have just tried to contact him because I didn't expect that we might call him today. But I don't know, maybe we'll hear from him this afternoon.
Officer, if I may just want to make sure that it's clear that I continue to have a standing objection to a lot of this testimony from Mr. Horowitz, particularly testimony about the toxicity of PFAS.
So would you speak up just a little?
Oh, I apologize. I'm sorry. I just wanted to make clear, because I wasn't clear from your last ruling, that this objection to Mr. Horowitz's testimony a large part of it. I have a standing objection to it on the record, especially the stuff about like risk communications. He's not a toxicologist. Toxicity, he's not a toxicologist. I just wanted to understand that that is a standing objection.
Yes, all right. Your standing objection is on the record. And before I forgot, I would ask you to send me and the other parties the document with the pink and purple highlighting that you showed on the screen.
Sure, I can do that. I just have to take some other information out of there that's not public.
That's fine.
Okay,
All
thank
right.
you.
I'm sorry for the interruption, Mr. Davis. You said you were going to try to contact Dr. Brown. We'll hear whether he's available or not. Commissioner Bloom, were you finished with your questions?
And just one more question. Mr. Horowitz, we heard from both the OCD and the Oil and Gas Association of New Mexico today that look at my question again here. That we need a narrower definition of PFAS because there are some PFAS chemicals that can't be tested for. And I'll ask this if there are witnesses as well. Any reaction to that?
I would say that's outside the scope of my testimony.
Okay. Mr. Horowitz, one of the concerns I would have, and I think somebody mentioned ingredients in the foods we eat. I feel like I'm getting into law school type questions here, or those sorts of hypothetical situations. But would it make sense to not say you couldn't put a novel poison in food because we can't test for it because no test exists, for example? And if you're still not comfortable answering these sorts of questions, I think theoretically what I'm struggling with is we can't ban something because we can't test for it would say that there are other sorts of things we couldn't introduce into certain types of supply chains simply because we don't have a test for them yet.
I think I can just generally speak to this and maybe add one specific point. I think the regulation here that's being proposed falls generally under taking precautions based on what we do know to prevent very serious harm in the future based on what we don't know. I mean, we do know that there are 9 different types of PFAS that are regulated in drinking water by, I think it's 8 different states and the EPA. Not all of the states and the EPA regulate all of the types, but they, together they regulate those types. And we know from the Intergovernmental Technology and Regulatory Council, which is a consortium of states that come together to work on various issues, that there's very little that for the PFAS that have been studied for toxicology, we know that those are mostly the ones that are regulated, and they're regulated at very, very low concentrations in drinking water. And you can look at the state regulations, you can look at the EPA's regulations, and draw your own conclusions about the toxicity there, but they're very low concentrations. And so based on what we know about the ones that have been studied, it would be prudent to act with caution and say, this class of chemicals, from what we know, is very dangerous, and let's have a prohibition on their use, especially in this process, oil and gas extraction, that EPA has found has multiple potential pathways for water contamination. That's in the EPA's 2016 report on fracking and drinking water. This is not, inside a laboratory where, chemicals can be carefully controlled. This is, outside where you're injecting chemicals under high pressure. You can have leaks, spills. The well integrity can be compromised underground. chemicals can get out into the drinking water. And that's happened in New Mexico. That's been documented in those documented cases of pit leakage led to the New Mexico pit rule. So there is some evidence here in New Mexico that, yes, there are pathways with oil and gas operations that can lead to water contamination. And you've got this class of chemicals that has some very, very high levels of toxicity associated with it. And so it's based on that information, it would be wise to put a prohibition on the further use of these chemicals in oil and gas wells.
So just two last quick questions. Mr. Horowitz, so you're an attorney.